হিউসেন দিয়েছিলাম তার আগে তো আপনার মানে মুড দিতে আমার লাস্ট আমার এই 27 বছর আপনার কথা দিছিল আপনি দিতে পারেন এখানে আমার পোয়া নাই আপনি আজি এসে দাঁড়িয়ে গেছে আপনি ডেটটা মানে
When it was filed,
Lordship, it was filed on 24/4, 24, Your Lordship.
what is the difficulty?
Lordship, some certificate copies are required, Your Lordship, to be filed. So I have applied for that, Your Lordship.
On the prayer being made by Mr.
I.S. Laskar.
I.S. Loskar, Learned Counsel for the Appeals. This is the matter after vacation.
Filed, Your Lordship.
Promotion bail application, item number 1.
May please, Your Lordship. 439 application, my lord. The Lordship will find the FIR at page 13, my lord, 13, my lord. May I read, my lord? With due respect, I would like to state that my father, late so-and-so, was the owner of a plot of land measuring so-and-so, covered by Dag number and Patta number so-and-so, village so-and-so, my lord. After the death of my father, I came to know that my brother, Urupjyoti Das, name was mutated in the Jamabandi without my and my sister's knowledge. Immediately, I filed an RTI asking for the details about it. After receiving the RTI reply dated 29/7/2023, along with the affidavit dated 21/05/22, I came to know that my brother, namely Sri Ghaneshyam Das, Navajyoti Das, Urupjyoti Das, has jointly forged my signature along with my sisters, namely Pranita Das and Srimati Jonali Das signature in the affidavit dated so-and-so and notarized before the notary S.N. Devnath, who sit at the office of the CGM Kamrup Metro and produce the same before the Guwahati Office Revenues DC Metro for granting mutation done in the name of Urupjyoti Das. Well, here, my lord, I am a Jari Karok, my lord. My lord, if your lordship now turns to my lord, page 16 for a once, my lord.
Jari Karok of which office?
My lord, Guwahati Circle. Page 16, my lord, the forwarding report, my lord.
When you were been arrested?
Yeah, my lord, I was arrested on 11/6/2024.
Yes. What are the grounds?
My lord, now, my lord, page 16, my lord, ground of arrest 4, my lord, serial number 4, my lord. The arrestee number 2, whose current position is a Jari Karok, he did not perform his duty and he did not provide the notice to the second party. Instead of serving the notice to the second party, he served the notice to the petitioner of the land, my lord. This is the allegation against me, my lord. Now, my lord, in the instant case, my lord, I have been served with 41A notice, my lord, from page 19 onwards, my lord. Page 19, my lord. 19, your lordship will see, my lord. I have been asked to appear, my lord, on 1/6/2024 at 1 p.m., my lord. Lordship have found, my lord. Below, my lord, date and time of which your attendance is required. My lord, next page also, my lord, I appeared, my lord. Next page also, my lord, lordship will see, you are requested to on 6/6, page 20, my lord. Again, my lord, 21, my lord, on 10/6, my lord. On 10/6, I was asked to appear. On 10/6, I appeared, my lord. And again, page 22, my lord, again a forwarding, my lord, 41 notice has been served, my lord. On the same day, my lord, the first paragraph, my lord. In exercise of the power conferred under subsection 1 of section 41A CRPC, I hereby inform you that investigation of FIR case number so-and-so requested at police station Panbajar, it is revealed that there are reasonable ground to question you to ascertain facts and circumstances for you in relation to the present investigation. Hence, you are directed to appear before me at 1 p.m. on 16/6/24 at Panbajar police station, my lord. Well, 16/6, my lord, I was asked to appear, but on 10th, I have been arrested, my lord. And now, if your lordship sees, my lord, next page, my lord, page 23, this is the order passed by your lordship, my lord. My lord, the person, my lord, who, my lord, forced the signature, my lord, he was granted bail, my lord. Page 23, my lord.
So let the city come
my lord.
tomorrow or day after tomorrow.
Panbazar.
Locker.
Day after tomorrow.
City. Day after tomorrow. Wednesday.
On 26, my lord.
26. Study number 2.
But two, it's a second bill application, my lord. And the ground, my lord, which I have taken in the news, in this petition, my lord, the ground of LEB, my lord, I was not present, my lord, at the time of the occurrence. The lordship, please, just, my lord, call for the case very much.
No, what is the ground for filing this?
My lord,
second
filing of this case, my lord, at the time of the occurrence, my lord, I
Hmm.
was not present, my lord, at that time, my lord. And if your lordship sees your lordship's order, my lord,
Whether that plea was taken in the first bail application?
that was not taken, I think, my lord.
11.
The earlier bail application is at page number,
Okay,
bail order is at page number
at page number, my lord, 21, my lord.
21. This is AB.
AB, my lord. It's AB. Paragraph 5 is the important.
Okay, CD on Friday
It will come from Kubri lordship. So
After vacation.
after vacation. After vacation.
Can it not 16? It
On
not-
16.
16.
Item for
I'm on that.
item 3.
Please, Your Lordship. The lower court has fixed the date on 29th for necessary orders, my lord,
Oh, on SARS.
on the charge, my lord, on our
So
discharge
hearing is
application.
over.
So,
Here, SARS hearing is over.
charge hearing is over. We have argued our part,
Hmm.
and the learned PP below he was supposed to submit his reply, but he did not submit his reply.
Hmm.
It has been kept for necessary orders,
Hmm.
my lord, on 29th of this month.
So let it be done after
After
vacation.
vacation, my lord, any day. My lord, may I make a request? My
Yes.
lord, if your lordship kindly makes an observation that pendency of this application will not be a bar to decide that matter there. My
that
lord,
is not required lordship because this is not a repeated.
no, though there is no stay, my lord, because from my personal experience, because I had appeared before the learned court below and argued the matter,
Hmm.
the learned session judge was finding some difficulty because we have challenged the cognizance
Hmm.
of the cognizance
Hmm.
before this honorable court, my lord.
Hmm.
So if your lordship can make this observation, then
I don't, lordship, I don't think lordship because there is no, when there is no stay
I'll leave
lordship,
it to you. I'll leave it to your
how
lordship.
that, why that question
What
comes?
I felt, my lord, the learned session judge was expressing some difficulty because since this application is pending, he was finding some
Yes, some
difficulty in.
departmental cases lordship, then
No, there is no stay, my
government
lord.
authority,
No.
departmental cases, then repetition pendency shall not be a bar to decide the
I'll
case.
leave it
That
to your, I'll
comes
leave it to your lordship.
Yeah, no.
Okay, as requested by Mr. Theo Goodman, please.
D. Goswami.
Learned counsel for the petitioner. And being not objected by learned additional PP, the SSL list the matter immediately after reopening in the vacation. It is clarified that pendency of this petition will not be a bar for the learned trial court to proceed with the case pending before it.
18 July.
Deeply
Item 5. Item 5.
None appears for the accused on call.
On earlier occasion also unappeared lordship.
Huh?
On 18/6 also they appeared. Nobody was appeared lordship.
However, Mr. P.S. Loco, learned additional will be present and pointed out that on 18/6/2024 also, the learned And the learned counsel for the
Yeah, fine.
accused remain absent. The event of subsequent non-appearance, appropriate order shall follow.
Item 6. Item 6. Item 6.
None appears for the applicant on call, recessal is the matter of the application.
Item 7.
Lordship, here in this case, we have received the CD, but it is not updated, Lordship. He and the interim was given on 3/4/24, Lordship. But CD is updated till 1/3/24, Lordship. So, Lordship, let me know whether he appeared or not, let us.
He appeared, Your Lordship. That date is not known to me, Your Lordship, but he appeared in any statement was also recorded, Your Lordship.
When he appeared.
I don't know the actual date, Your Lordship. Correct date.
So what is the stage of investigation?
Yes, some with some statement of the witnesses has been recorded, Lordship. And
So do you think that his custodial intervention is required in view of the?
as it is not updated, Lordship, I have not gone through the entire.
No,
situation.
So we have granted the interim protection on 8/4/2024.
I may take verbal instruction from the
So can I see the case ID?
Lordship.
Heard Miss S. Nazneen, learned counsel for the applicant, and Mr. P. S. Locker, learned additional counsel for the Pair number 20. Ms. Nazneen, learned counsel for the applicant submits that the applicant was granted the privilege of interim hearing bail by order dated 8/4/2024. And thereafter, the applicant had appeared before the IO and cooperating with the investigating agency. And in that view of the matter, Ms. Nazneen contended that the interim order dated 8/4/2024 may be made absolute in the same terms and conditions. On the other hand, Mr. E. S. Locker, learned additional PT, has produced the case ID before this court and submits that the case ID has not been updated. However, Mr. Locker, referring to the materials available on the record, available in the case ID, submits that the IO has examined some witnesses and also
সাইটার এদের দিতে কোথায় একটু আপডেট করতে হবে পুলিশ গুলো কারণ
and also arrested some of the accused persons. Further, having heard the submission of learned advocates of both sides, I have carefully gone through the petition and the documents plus on record and also whereas the case ID. So produced by Mr. Locker, learned additional PP. Further, in view of the materials collected so far in the case ID and also in view of the fact that the applicant had been cooperating with the investigating agency, his custodial interrogation seems to be not warranted here in this case, and therefore this court is inclined to make the interim order dated 8/4/2024 absolute in the same terms.
Deeply observed.
Case ID be rendered.
Item number 8. Matter for orders.
My lord, that report from the FSL was called for, my lord, in this case. And I had, my lord, submitted a petition for, my lord, recall and vacation of the stay order which was passed in this matter, my lord. My lord, my submissions before this court was that, my lord, the FIR, my lord, which has been filed, my lord, it makes out offences under which it has been registered, my lord, and that is why, my lord, there should not have been any stay, my lord, in this matter, and the investigation should have been allowed to continue, my lord. Lordship was pleased to call for a report from the FSL manner. It is there with my learned
Yes.
friend, my lord. Lordship. Can
You
see?
received the report.
Yes, sir.
The other counsel remain absent today.
He is not appear. I don't know, my lord. He is not here.
Okay. I see. You were for the respondent.
I am for a respondent. Complainant.
You were the Sanjay, you were Sanjeev Buragohain.
Sorry, bro. I am the complainant, my lord. Huh? Why?
So, where is the FIR?
FIR is at page, my lord, 43 of the repetition, my lord. May I read the FIR, my lord?
Not
Your
necessarily.
Lordship, as per the FSL report, Your Lordship, the signature of the Sanjeev Buragohain has been taken and his signature doesn't match with the signatures that were put in the loan papers, Your Lordship.
Mm,
As such, Your Lordship, the signatures of the accused person in the FIR has been taken
mm.
and it is sent to DSFL for further investigation, Your Lordship, means for further examination, Your Lordship.
For?
For further examination, Your Lordship. Since the signature of Sanjeev Buragohain does not match with the signatures in the loan papers
Mm.
done by Sanjeev Buragohain, that's why, Your Lordship, the investigating agencies have again taken the signatures of the accused person and have sent the same to DFSL for further examination, Your Lordship. And we are
Again?
awaiting the reports, Your Lordship.
Again.
Again, Your Lordship.
No, my lord. What happened? When, my lord, my
No, no,
my
the
allegation-
report is available. That
Yes, yes.
Available, Your Lordship, but the red enclosed signatures, that red enclosed signatures sheet is not available here, Your Lordship. It
No,
is
no, but-
again sent to DFSL along with the signatures of the accused person, Your Lordship.
May I explain, my lord?
Your
What she's
Lordship,
trying to say?
it's written in the CD, Your Lordship, last page, I suppose, Your Lordship.
so when it was taken?
Your lordship, the date is not mentioned there, your lordship.
Now, what is your submission?
Your lordship,
Or,
until the
we are,
father,
oh, we are dealing with the IA now.
yes, your lordship.
Okay, do you have the number of the council? Wait for some time, the advocate is coming.
For hearing, item 9.
Maintenance. Lord, I was, my lord, and for the respondent wife, I was supposed to submit how much money I have received till now.
Out of?
Out of, my lord,
is saying page 58, annexure 3, my lord. Page 58. This, my lord, is a joint written statement. Page 58 is a joint written statement filed by the informant and his wife. At the right hand side, my lord, you can see the signature of both the informant and his wife. The relevant part, my lord, is at page 61. Relevant part is at, my lord, page 61, paragraph number 8. My lord, I'd like to read that. Here, the answering respondents are the informant and his wife, Your Honor, my lord. That the answering respondents, while denying the statement made in para 4 of the affidavit, begs to state that only ground and first floor of the building was constructed by the husband of the petitioner, a retired BSF commandant, and the second floor of the building was constructed and completed by the answering respondent number 3 at a cost of around rupees 35 lakhs only in April 2021, as per the notarized agreement dated 17/3/2020, entered into by the respondent number 3 with the respondent number 2, wherein it is mentioned that the respondent number 2, this is the important part, wherein it is mentioned that the respondent number 2 availed a loan from UCO Bank from an account for an amount of rupees 25 lakhs, approximately by mortgaging the joint property in the year 2016 for constructing the second floor of the aforesaid RCC building. And accordingly, after obtaining the loan amount, the said floor was partially built. It is further stated that in the said deed of agreement that the respondent number 2 again took a loan from ICICI Bank in the March 2018 by mortgaging the ground floor and the first floor of the said property. The loan amount of UCO Bank was taken over by the ICICI Bank, and then another top-up loan of rupees 26 lakhs was sanctioned by ICICI Bank to respondent number 2, and the details of the loans are mentioned this and this. This is the exact loan mentioned in the FIR, my lord. Then he says where he availed a loan of 27 lakhs 8,526 rupees and another loan of 26 lakh 32,994 rupees. It is further mentioned in the said agreement that as the respondent number failed to pay the EMIs regularly to the ICICI Bank for the 4 to 5 consecutive months, the bank had warned him of declaring the loan as non-performing asset. And as such, he approached the respondent number 3 with a request to take over the housing building loan and repay the principal amount as well as the interest amount to the ICICI Bank. Agreeing to such proposal, my lord, this is again an important part. He says, the informant says, agreeing to such proposal of the respondent number 2, the answering respondent number 3 took over the loan and repaid the backlogs of the defaulted loan and is repaying the EMIs with an objective of repaying the total principal amount loan. The entire outstanding amount and additional interest of the loan to the bank on behalf of the respondent number 2. In return, respondent number 2 agreed to transfer his respective share, including both land and building, that is part and parcel of second floor of the 2-story RCC building measuring 2,240 square feet, along with the undivided proportionate share of land. most specifically described in the schedule of the said deed, which was witnessed by the petitioner and respondent number 1, meaning thereby the respondent number 2 had relinquished all his rights and interests in the said property. Then, my lord, he annexed the said agreement. He annexed the said annexure number 1 is the deed of agreement between the informant and accused number 3, my lord. That is at page 98. My lord, this agreement is his agreement, his document, my lord. Now, as per his statements, he has not mentioned anything about forgery. He is saying that the loans were availed by his elder brother, who's been added as accused number 3. He took the loans, but then during, my lord, that is during the pandemic, he lost his job. He could not pay the EMIs. So the accused number 3 approached the informant, saying that you take over these loans, in return I will give you my share of the RCC, my share in the property. The informant agreed. They entered into an agreement. This is the admission before the trial court. He says that I'll take over the loan only on one condition: if you relinquish your rights in the property. So both entered into an agreement, and then he has been paying the EMI since 2020, my lord. But then in the FI he says that he came to know about the alleged incident in the year somewhere around December 2022, which is again a wrong statement, my lord. Now, my lord, now the question arises, my lord, that is why has the informant then filed this FIR when he is himself voluntarily taken over this loan according to this agreement, my lord. This agreement, he has voluntarily taken over the loan, the informant. Now the question arises, my lord, then why has the informant filed this FIR? Because of the DV case that the mother has filed, my lord. What has happened is, my lord, now the mother expected her younger son, that is the informant, to assist the family during the pandemic. The mother says you were expected to help your brother who has lost his job during the pandemic, but instead of helping your brother, you are asking your brother to relinquish your rights in to relinquish his rights in the property. So the petitioner, my lord, the mother says, if you do that, then okay, I will give my share in the property to the son who is now homeless.
Mr. Singh, the player in this writ petition is to quash the FIR,
My lord,
right?
my lord.
So we are to see only whether a prima facie case is made out or not
My lord.
from the allegation made in the FIR.
My lord, doctrine of estoppel will be applicable because it is already stated in the trial court that he had the knowledge, he himself has been paying the EMIs. Now, my lord, he says that, because he is saying because the trial court order has went against him, he's prejudiced with that order. And it is not, my lord, that he has not tried. My lord, my intention is why to tell the court because why he has filed this FIR, and that will be necessary, my lord, to understand that why this FIR is being filed. He himself has admitted before the trial court he had the knowledge, he himself has been paying the EMIs, but these things has been suppressed in the FIR. Again, my lord, but then why has he filed this FIR? To understand that, my lord, the chronology of events will be necessary, my lord. That is why I'm insisting what has happened before the trial court. Because my lord, he was of the opinion, when he took over this loan, he was the opinion that now the entire second floor is his, as per his agreement, and also the ground floor. But then problem arose, my lord, when the mother said, I'll give my share of the property to the son who is now homeless, that is the accused number 3, the informant was prejudiced. The informant is telling the mother, I've been taking care of you. Your other 2 sons, they are not even staying in the property. If you give your share of your property to the other son, there will be consequences. My lord, this is what he means by consequences. He first committed domestic violence. He threw his own mother out from the home. This is a report by the protection officer. And then when, my lord, the trial court still gave an order against him, my lord.
No, Mr. Singh, that kind of a roving inquiry this court cannot undertake in view of the judgment of Supreme Court in the case of Niharika Infrastructure.
My lord, there is, even I have a judgment, my lord, there is a similar case was there.
When?
The recent 2024 judgment, my lord.
Whether the ratio laid down in the case of Niharika Infrastructure was taken into account in that judgment?
No, my lord, that has not been taken. But then, my lord,
Then, what is the strength of the bench?
this is, my lord,
2 judge or 3 judge?
double bench judgment, my lord.
Niharika is 3 judge bench decision.
My lord, that is doctrine of estoppel will be applicable because, my lord, that is, he has already admitted before the trial court. And my lord, and this judgment that I am relying on, the sections are very similar. In this case, what was happened is, my lord, that is, the dispute was between husband and wife. The husband alleged.
Okay, let us do one thing. We finally hear the matter. Are you ready?
Yes.
Yes. You argue finally then. You have already perused the FIR
My lord.
and also pointed out this page number.
43.
Yes, 58.
My lord.
Any other point?
My lord, before filing this FIR, it is not that the informant has not tried other things. Because, my lord, as I've submitted, he was prejudiced his mother's decision to give her share of the property to the other son. Now, the informant says, my lord, that the writ petitioner cannot do that because he's been taking care of the mother. And if the mother tries to give her share of the property to the other son, then he'll withdraw. He'll not pay the EMIs. Now, my lord, now it is about specific performance of the contract also, because this is his agreement, that is which he has annexed before the trial court.
This is a criminal case.
My lord, I understand, my lord.
There is for crossing the FIR only.
My lord, I understand, my lord. It's only, my lord, I'm trying to convince, my lord, that is why he has filed the FIR. And that chronology will be, my lord, necessary. Because, you know, it will be necessary to understand why he has filed the FIR, my lord. Now, my lord, before filing the FIR, he first manufactured a false will of late Captain L.P. Bourgoin. False will. That also annexure, my lord, I have annexed it at page 98, that, my lord, page 93. That may also be kindly looked into, my lord.
Yes.
Page 93, my lord, he says that his father, late father, has executed a will. And the relevant part is at page 95, my lord. No, that is at page 95. Relevant part is at page 95. I'll read the relevant part, my lord.
Yes.
That after the death of my wife, the whole of the ground floor will be the property of my youngest son, Shri Sanjeev
You are reading
Bourgoin.
point number?
Point A, my lord. Part B.
Yes.
Page 95, part B.
Yes.
That after the death of my wife, the whole of the ground floor will be the property of my youngest son, Shri Sanjeev Bourgoin, and his wife, Srimati Priyanka Sekia Bourgoin. My lord, he says that because the mother has chosen to give her share, that is the ground floor of the property, to the other son, now who is homeless, he manufactured this will, telling that the mother cannot do it. Now, my lord, when the trial court said that you produce this will in original, he then contradicted his statements, my lord. Then, my lord, at annexure number 4, at page 103, this is the contradiction, my lord. Page 103, this is the page 103, my lord. My lord, this is the counter DV case filed by the informant's wife. That was the joint written statement filed by the informant and his wife, telling that they have, that the late father has executed a will. Now, in this DV case, my lord, he says, the informant's wife says, relevant part is at my lord, page 105. Relevant part is at 105, paragraph number 7. That the
Page number?
105, my lord, para 7.
Yes.
That the complainant aggrieved states that it is also worth mentioning here that though the property of the father-in-law was not formally partitioned and her father-in-law died intestate. Intestate meaning, my lord, that he had not executed any will, but now in the written statement they have produced a will. These are, my lord, relevant developments, because when the trial court said that you produce the will in original, he could not do it. The trial court, my lord, then passed an order by which he was prejudiced. I have annexed that order also, my lord. That order is at annexure 2. Page 45, my lord.
Yes.
Now, operative part is at page 56, my lord. Page 56, the operative part of the order.
Yes.
My lord, the last para, that is after the perusal of definition prescribed in the statute, entire material placed before this court, an objective view that has been taken by the Honorable Supreme Court, and also considering the gravity of the matter and the fact that restraining respondents from committing any act of domestic violence would not prejudice them, the court deems it fit to issue following direction to the respondent. Respondents are restrained from committing acts of domestic violence upon the aggrieved. Respondents are restrained from perpetrating further acts of domestic violence upon the aggrieved person. Respondents are hereby restrained from communicating in any matter with the aggrieved person. My lord, the point number 4 is important, my lord. That is, the respondents are hereby restrained to keep their ferocious dogs within their own premises of the building, that is in the second floor of the building. Now, my lord, I'm afraid to say this because, my lord, it will only pain you to realize to what extent has the informant gone to inflict pain upon her own mother, only for the greed of property. And my lord, when he could not succeed, when the direction was given by the trial court to remove the ferocious dogs, along with this, there was a safety plan recommended by the protection officer that recommended for the removal of respondent number 2. That safety plan, my lord, has also been annexed. That is the last annexure. This safety plan was prepared by the protection officer, my lord. That is annexure number 8, my lord, 121, page number 121. Below page 125, this is the safety plan under the DV Act, Form 5, Rule 8, subsection 1(4). This power is with the protection officer and, my lord, with the police officer. They too can recommend a safety plan to the trial court for the safety of the aggrieved person, my lord. Now, this is a recommendation by the protection officer. At serial number 1, my lord, what does the protection officer say? I want to draw the attention of the honorable court, my lord. On the right hand side, my lord, it can say, you can, my lord, see it, removing respondent and his ferocious dogs from the ground floor, removing respondent number 3 and his ferocious dogs from the ground floor. This is the recommendation of the protection officer, my lord. And further, my lord, at page number 122 of the said safety plan, page number 122 of the safety plan, my lord. At serial number 8, the protection officer then states that the informant has been forcing to repay the loan. He has been forcing his mother to repay the loan. Because, my lord, he is now of the opinion, if mother is, because, my lord, in any commercial or residential building, the ground floor is the most costly, my lord, that is, the market price is quite high. He is prejudiced that the ground floor should not be given to the brother. If you do that, there will be consequences. That is why when the mother said, my lord, that is, I will give my share of the property to the son who is now homeless, he is forcing the mother to repay the loans. This is the protection officer is saying.
Further, if I may, my lord, interject, my lord. Perhaps we are, my lord, traveling beyond the contours of, my lord, 482 now, my
No,
lord,
my lord,
petition, my lord.
My lord, because it is necessary
Because the parameters of 482,
My lord,
let him confine to only that, my lord.
because, my lord, it is necessary to understand.
This is my humble submission, my lord.
My lord, I am trying to convince the court. My lord, I am trying to convince the court that it is a frivolous FIR filed. He has tried multiple things before filing this FIR. This is what I want to bring into the account of the honorable court, my lord, and this is relevant because, my lord. Further, my lord, the protection officer says at page 123, serial number 13, my lord.
Wait a minute. Mr. Khatuniar. So you please come at 2 p.m.
Yes, sir.
Was just 5 minutes.
Yes. Page 123, my lord, that is serial number 13. The room of the aggrieved person is very unhygienic and the home is filled with strong stench coming from the dogs. And Mother Milord, the protection officer says maid housekeeping required for the aggrieved person for her daily care and well-being. She's being deprived so that she can be compelled to move out from the residential house, my lord. This is a report of the protection officer. Further, at page 124, the protection officer says water supply to the bathroom be restored because the informant has deliberately cut the water supply of the bathroom so that the petitioner can be thrown. She can be compelled to move out from the house. Then, my lord, at page 125, 22, serial number 22, the protection officer is of the opinion that the respondent number 2 is habitual in his disrespect and disdain for law. Because, my lord, the protection order that was passed, he was specifically ordered to remove his ferocious dogs from the ground floor, which he has deliberately kept so that the mother can be compelled to move out. He has not done that, my lord. Now the protection officer visited the premises to appraise him that he is supposed to follow the order. And the protection officer, my lord, submitted a safety home visit report that is at page number 120. Now, this home visit was done by the protection officer and also by an NGO named Sakhi that is under the Ministry of Women and Child Development, my lord. This home visit report is also relevant, my lord. I'll read the relevant points. That is from the middle, my lord. Both the parties of this case, my lord, from the middle, both the parties of this case have been residing at the same shared household and sharing the same common drawing room and kitchen. The Honorable Court has passed an interim relief and issued directions to the respondent to refrain from committing any act of domestic violence upon the aggrieved. And respondents are restrained to keep their ferocious dogs within their own premises. But during the home visit, it was observed that the respondent Sanjeev Borgohain was imposing some allegations against the aggrieved, and one of the dogs was moving freely within the drawing room. This seems to be a clear violation of Honorable Court's order. These things may be taken note of. That is, what is the intention of filing the FIR, my lord. And all these relevant points will suggest that the FIR is prima facie malicious. He wants, my lord, that is, he has himself admitted before the trial court that he himself had voluntarily taken over the loan. This is an important point, my lord. He himself has admitted, and over there, my lord, in the agreement that he has annexed, it is his document, my lord, that is at page 98, my lord. This is his agreement. Page 98, my lord. Page 98. This is his agreement, my lord. That is, he has produced before the trial court. He is telling in this agreement, my lord, which is the date is also very important, my lord. In this agreement, he says that on 17th day of March 2020, he himself voluntarily took over the loan. And the relevant part of this agreement is page 99, my lord. Second last para. Page 99, second last para, my lord. Page 99, my lord, second last para. I'll only read the relevant part, my lord. This is where he says, second last para, whereas the first party, namely Mr. Santanu Borgohain, availed a housing loan. And my lord, over here, the petitioner's name is not mentioned. He himself is telling that who took the loan. It is accused number 3 who has taken the loan. He says, my lord, whereas the first party named Mr. Santanu Borgohain availed a housing building loan from the UCO Bank from an amount of rupees 25 lakhs, approximately in the year 2016, for constructing the said floor of the property. Whereas the first party, Mr. Santanu Borgohain, again took a loan. My lord, this is also important. He's telling that accused number 3 is the person who has taken the loan. The mother is nowhere involved. She's a co-applicant. My lord, that is the only thing that is against her, that is, she was the co-applicant in this loan. But now further, my lord, he says, whereas the first party, Mr. Santanu Borgohain, again took a loan from ICICI Bank in March 2018 by mortgaging the ground floor and the first floor of the said property. loan amount of UCO Bank was taken over by the ICICI Bank, and then another top of loan of rupees 26 lakhs was sanctioned by ICICI Bank to Mr. Shantanu Borgohain. Now, my lord, further he says this is the loan amount mentioned. Further, he says, whereas the first party has failed to complete the construction of the second floor of the aforesaid building and also fails to repay the EMIs regular to the ICICI Bank. As on date, the first party has his outstanding EMI of the first loan as so and so rupees, and outstanding EMI for the second loan as this and this rupees. The first party has already failed to pay the EMI for the 4 to 5 consecutive months, and the lender, ICICI Bank, has warned him of declaring the loan as non-performing assets. Now, my lord, further he says, whereas the first party has expressed his inability to repay the EMIs of the aforesaid loans to the bank, and therefore approaches the second party, that is the informant, Sanjeev Borgohain, with a request to take over the housing building loan and repay the principal amount as well as in the interest amount of the ICICI Bank. My lord, further at further relevant para, he says, now the second party being a brother, this is also important, my lord. Now the second party is the informant here. He says, now the second party being brother and also having responsibility of each other, agrees to undertake the stake over the said loan and repay the entire outstanding amount to the bank on behalf of the first party. It has now become imperative for the parties herein to write down the terms and conditions to avoid future misunderstanding, my lord, dispute and differences between them. And this is the document, my lord, he has annexed. Now, my lord, where is any doubt left, my lord, that the loan was taken with his consent and his knowledge? He himself is telling this before the trial court. And my lord, it is not this, I have only, this is not the only document that I have, my lord. He has further written letters and emails to the bank officials, which I have annexed in my IA. In my affidavit in opposition to the IA, my lord. My lord, my affidavit in opposition to the IA that they have filed, over there I have annexed annexure 9 at page 28. Last page, my lord. My lord, annexure 9, page 28. Affidavit in opposition, my lord. This is an email that the informant has sent to the bank officials, my lord. Right at the middle, my lord, you can see his name, Sanjeev Borgohain. He has written to the bank officials at the end of the document, my lord, that is on Wednesday, June 3rd, 2020. He is writing to the bank officials, as discussed, please find the copy of the scanned letter and copy of the notarized agreement between Shantanu Borgohain, and please take necessary action and let me know. He's informing them, my lord, he's informing the bank official of the notarized agreement. He's telling that, and I have taken over this loan agreement. He is paying the EMIs regularly since 2020. And then, my lord, in the FI, he says, my lord, that he came to know about this forgery in the later half of, at the end of December 2022. Further, my lord, on day 1, Learned Counsel was making a submission, but he stopped himself. He was telling, my lord, that in the first loan that he had given an NOC, no objection certificate. It is still there, my lord. His submission is still there online. Maybe, my lord, as I pray, he may be asked to clarify that what he means by this submission. Because if in the first loan he has given the no objection certificate, that means he had the knowledge and the consent was there. This is, my lord, but then he stopped himself.
Okay. What is the judgment you have relied upon?
My lord, this judgment is Criminal Appeal 335 of 2024 between Mariam Faizuddin and
Yeah,
others versus
can
state and others.
Furnish a copy to the court.
My lord. My lord, this judgment discusses about the FSL report. My lord, I've highlighted the relevant portion.
Paragraph number 30.
Yes, my lord.
Yes.
I'll only read the relevant portion, my lord. It talks about the FSL report, my lord. In this case, what has happened, my lord, the charge sheet was filed. It is a dispute between husband and wife, where the husband had alleged that the wife has committed forgery for obtaining the passport of the minor child. And then the husband says, my lord, that I was not even present in India when this passport application was applied for. Because for obtaining the passport of the minor child, both the signatures of required, my lord, of the wife
Mother and mother.
yes, my lord. My lord, the charge sheet was filed. The accused wife applied for discharge application. That was not considered. She approached the High Court. The High Court did not entertain. Further, then she appealed before the Honorable Supreme Court. And my lord, again, the informant in that case was also relying on the FSL report, that the FSL report states this and this, that the forgery has taken place. So the trial is necessary, my lord. But then the Honorable Supreme Court decided the matter on the merits, whether the ingredients were present or not, and decided on the fact that whether FSL report can be the only ground to allow the trial to take place. Milo, that para is relevant, that is on page 30. We also fail to understand the reliability of the material based on which the investigation agency or the trial magistrate could form a prima facie opinion concerning the allegation of forgery of signatures of respondent number 2. As observed earlier, the state FSL report does not substantiate these allegations. In our opinion, a paid report obtained from a private laboratory seems to be frail, unreliable, unsafe, untrustworthy, an imprudent form of evidence, unless supported by some other corroborative proof. It is painful to mention that the respondent number 2 has not produced any other substantive proof, nor has the investigation agency obtained any such material in compliance with the trial magistrate's order for further investigation. The basis on which the trial magistrate formed a prima facie opinion in absence of such supporting evidence is therefore beyond our comprehension. This is, my lord, the important part. That is the Honorable Apex Court's, to my, again, my lord, understanding what the Honorable Apex Court's opinion is, that the opinion of FSL report must be supported by some other form of evidence, my lord. Because the FSL report, my lord, is based on an presumption, it is probability. There could be numerous reasons for the signature mismatch, my lord. In this case, the informant himself is admitting before the trial court that he himself had voluntarily taken over the loan, my lord. Now, if we consider that relevant admission before the trial court, then the necessary ingredients, my lord.
No, we are not sitting in appeal or in revision now.
Lord.
Yes, any other judgment?
No, my lord, that is what the only FSL report, that is this, their argument is based on the FSL report. So, my lord, my submission, I just wanted to bring this particular judgment by saying that, my lord, FSL report must be supported by some other form of evidence. And in our case, there is no further evidence that would corroborate the fact that there was some kind of forgery. Plus, my lord, my submission is that his own admission before the trial court that he himself has voluntarily taken over the loan, and these facts which he has suppressed in the FIR are also relevant. And the fact that, my lord, that the FIR has been filed after such a long delay, that delay cannot be a reason for quashing the FIR. I understand, my lord, but that in unexplained inordinate delay, unexplained inordinate delay can be a ground for quashing the FIR, my lord, because they have not explained the reason. He's telling that I came to know in December 2022, but he himself has been paying the EMI since 2020, my lord. This relevant information, he has suppressed it.
Okay. Hello. Yes, Mr. Sodori.
Well, basically, as I have already submitted, my lord, the powers of this court while exercising power, my lord, under section 482 of the CRPC is rather circumscribed matter. The prayers which has been made in this petition, my lord, if your lordships kindly turn to page number 35.
Yes.
Under these circumstances, the petitioner accused number 1 with folded hand praised that the Honorable Court be graciously pleased to call for the records and proceedings of the case from the senior PI of the Dispur Police Station at Kamrup, Guwahati, and after perusal to set aside and quash the said impugned FIR dated 2/12/22, bearing number 2536 of 2022. Pending the hearing and final disposal of this petition, the proceedings of the impugned FIR for appearance further investigation may be stayed or suspended. The hearing of this present application may be kindly expedited to grant interim and ad interim relief in terms of prayers in B and C, to grant the cost of this petition, to order for such further and other relief orders and directives of the nature and circumstances of the case may require or justify, or as the Honorable Court may deem fit and proper in the aforesaid fraction circumstances of the case. Now with these prayers, my lord, he has brought in a big history and a bunch of papers, my lord. But basically, my lord, what remains is to be seen is that whether, my lord, a bare reading of that FIR, whether it reflects a prima facie case or not, my lord. And in that view of the matter, your lordships have been pleased enough to point out, my lord, Niharika's case, my lord, where, my lord, after Bhajanlal's case, perhaps, my lord, the Niharika's case today is the most celebrated case, and which is, my lord, taken up everywhere while deciding, my lord, cases of this nature. My lord, in paragraph 12.3 at page 439, my lord, in Niharika, my lord, the dicta of the Honorable Apex Court is, my lord, in Union of India versus Prakash P. Hinduja in paragraph 20, it is observed and held as under. Thus, the legal position is absolutely clear and also settled by judicial authorities that the court would not interfere with the investigation or during the course of investigation, which would mean from the time of the lodging of the first information report till the submission of the report by the officer in charge of the police station in court under section 173(2) CRPC, this field being exclusively reserved for the investigating agency. In, my lord, 12.5, it has been laid down, my lord. In Ujjal Kumar Bardhan, it has been observed and held by this court that unless case of gross abuse of power is made out against those in charge of investigation, the High Court should be loath to interfere all early premature stage of investigation.
No, Mr.
So, my lord,
Soburi,
these are all settlement. Now, the question is, my lord, while bringing
no,
this,
no,
my lord,
Mr. Soburi,
My
in the
lord.
last part of that judgment,
my lord.
Supreme Court has laid down some parameters.
Yes, my lord.
Based on which the court can quash
Yes.
the FIR.
Yes, my lord.
So my pointed query is whether the present case falls within the parameters of
It doesn't fall.
laid down in that case.
It doesn't fall, my lord. It doesn't fall because of the fact that, my lord, that this loan, my lord, kindly see, my lord, the loan which was obtained, my lord, initially from the UCO Bank, my lord, and because, my lord, the person who had taken the loan actually had, because the property is a joint property, my lord. The property had not been, my lord, partitioned. Now, to help that second brother get the loan, my lord, everybody had given there, my lord, NOCs to that you obtained the loan, my lord. Thereafter, when he did not pay, my lord, then, my lord, what happened? This loan was transferred to the ICICI Bank. When the loan gets transferred, my lord, what gets transferred, my lord? The actual loan which was taken by the UCO Bank, that gets transferred to the ICICI Bank, my lord. And thereafter also there was default in payment, my lord. And today lordships is aware, my lord, when there is a loan and there is a default in payment of loan, my lord, ultimately the entire property is at stake. And therefore, my lord, I volunteered that, okay, that to save the parental property, I will pay the installments, my lord. But the question is, my lord, the top-up loans. This is the FIR relating to the top-up loans of 27 lakhs and, my lord, some odd and some 26 lakhs and odd. If, my lord, my NOC is to be shown at that point of time, my lord, why is it that the loan, my lord, agreements and the loan, my lord, documents which were applications for getting the top-up loans does not contain my signature? Well, kindly consider difference, my lord. Suppose it is a loan of, say, 1 lakh rupees at one point of time. The EMI comes to 10,000 rupees per month. I say, okay, I am agreeable to save the entire parental property. I am agreeable to pay 10,000 rupees per month. I am paying. Suddenly, out of the blue, my lord, when the EMI comes out to 25,000 rupees per month. Now, these are just general, my lord. My lord, the amount is not, my lord, the actual amount. I am just generally stating, my lord. So then I will have to inquire, my lord, as to how that 10,000 rupees has risen to 25,000 rupees. And there, when I find out, my lord, that, my lord, these top-up loans have been availed by them And those top-up loans have been availed and they have been personally, my lord, used, my lord, by somebody. And my lord, they have executed documents to get those loans in my name also, my lord, showing me as a, my lord, as a person who has availed of the loans and the benefits, my lord, but then my signatures are not there, my lord, by forging my signatures. Whether I should not complain, my lord? That is a question I put to myself, my lord. So ultimately, my lord, if your lordship sees right from R.P. Kapoor, my lord, Bhajan Lal, and thereafter Niharika, those, my lord, conditions which has been laid down are more or less the same, my lord. The conditions have not deviated here and there, or nothing new has been added. So when that is not added, my lord, all these things, what is happening thereafter, my lord, as a counterblast, my lord, or by whatever form, my lord, these are not material for the court to see at this stage, my lord. That is my humble submission. Because, my lord, it is also the dicta of the Supreme Court, my lord, that why that investigation, my lord. My lord, this judgment which has been shown, my lord, this judgment in 24, this relates to a case where somebody was sought to be discharged, my lord, he was not discharged. Against that discharge, he went ahead, my lord. And thereafter, the Supreme Court came to certain findings, my lord. Well, this is a petition where they seek to nip the investigation at the very bud. Regarding all those other cases, my lord, whatever is there, we have been, my lord, contesting those cases. We have also given our written statements and we have given our version there, my lord. But that version, my lord, will be seen in the trial of those cases, my lord. What is applicable, what is not applicable, what liability we have taken, that will be there. But what about this fact, my lord, that you have obtained the benefit of a loan? Because till now, whatever has been said, my lord, by my friend, my lord, here, he has not stated that, my lord, these 27 lakhs and these 26 lakhs have been taken by me.
No.
So when I am not the beneficiary of, my lord, those top-up loans which they have taken by forging my signatures, my lord, definitely an offense has been committed, my lord. And if an offense has been committed in that manner where, my lord, my signature is, my lord, forged, my lord, for the sake of, my lord, obtaining money, my lord, from a public institution, my lord, definitely, my lord, a cause of action arises for me to approach the police station for investigation as to who have done it. Now he says the the accused number 3 has not done it. Then who has done it? Let him say. So until and unless this matter is investigated, my lord, and this embargo which has been granted by this court is lifted, my lord, the truth will not come out. My lord, I am paying the loan. It's not the fact that I am not paying. I am repaying the loan. But, my lord, I am also not repaying since the day, my lord, when this thing came out in my lord, to my eyes. Thereafter, my lord, to save that parental property, because lordship knows once it is, my lord, declared as an NPA, tomorrow, my lord, securitization proceedings will start. And thereafter, there can be no, my lord, going back on that, and that law will take whatever course it has taken. Every one of us will be, my lord, thrown out of that home. Because as it has been submitted by him, my lord, from the other side, lordship is clear, it is only I who have been paying the money, my lord. And it is also clear that I have not availed of the loans. The loan was availed of by the middle brother, my lord. He did not repay it. So then, my lord, how do you put a, my lord, color on my lord, actions where I am trying to save the property, my lord? He has read out the written statement which I have given, my lord. What is from the written statement? What gets reflected, my lord? What gets reflected is that, my lord, I am not willing them to sell the property. That is all. That is the basis of, my lord, all these squabbles between us, my lord. Somebody wants to sell the entire property, parental property, for their short-term gains, my lord. I am stopping them from, my lord, selling it. That is the entire, my lord, appointed, my lord, reason for the squabble. But then, my lord, these things will be settled at the appropriate forum, in the appropriate court, my lord, where it has been laid for consideration, it will be considered, my lord. I have my defenses, evidences will be laid, evidences will be understood, and all these things will go on. But the fact that, my lord, this FIR, there today, my lord, your lordship had called for, my lord, that report only to ascertain as to whether there was some amount of, my lord, correctness in the FIR or not. And that amount of correctness, the prima facie correctness which your lordship wanted to see, has been reflected by that, my lord, FSL report, which says that, my lord, on an examination of my signature as well as the signatures which appears in my name in that loan documents, it does not tally. So for whatever reason, there could be a mismatch, or whether it, my lord, matches or does not matches or whatever, that is a subject matter of the trial. But prima facie today, my lord, how can this court, my lord, and on that basis, my lord, the other side can say, my lord, the investigation has to be stopped, my lord? How can the investigation be stopped, my lord, today? The investigation cannot be stopped because of this, my lord. So within that particular parameter, my lord, at this stage as to whether, my lord, the investigation is to be, my lord, quashed or investigation is not to be quashed or allowed, my lord, the law is very, very clear, my lord, that at this stage of the investigation, my lord, the court will not interfere, my lord, because, my lord, ultimately, a bare reading of the FIR reflects, my lord, a cause of action. It reflects that offences has been committed, and that reflection, my lord, is today buttressed, my lord, by that FSL report which is before your lordship, my lord. There's some amount of hanky-panky is there. So if, my lord, why don't they say as to who has taken the money? Why don't they come up and say that they have not accepted the money from the bank, that the money was also accepted by me? That submission is not forthcoming because of the fact that the money was taken and digested by them, and the entire burden of saving the parental property is on my head, my lord.
My lord.
That is the reason I say, my lord, that, my lord, these, my lord, conditions which has been given in Niharika and is followed right from R.P. Kapoor, my lord, Bhajanlal, and now Niharika, my lord, is, my lord, actually not applicable in the facts of this case, my lord. And what is applicable in the facts of this case is the fact that, my lord, that within the parameters of 482, my lord, this FIR, it reflects a cause of action, it reflects that offences has been committed, my lord, and therefore, my lord, this is a petition which is liable to be dismissed, my lord.
My lord,
Okay,
If I may submit, my lord, just one thing.
wait for a while. Yes, madam.
I'll, my lord, submit, my lord, there is one more judgment, my lord. That is AIR Online 2018 Supreme Court 954. There also, my lord, in paragraph 27, it was held, my lord, that in so-and-so case, held that in the absence of compelling and justifiable reasons, it was not permissible for
citation
this
is
court to
AIR?
stop. My lord, AIR Online, I'll give a copy, my lord.
Okay.
AIR on, give me copy it again. Yes. My lord will first take up paragraph 27, my lord. Has your lordship got it, my lord?
Yes.
In Messrs. Giant Vitamins Limited versus Chaitanya Kumar and another, this court held that in the absence of compelling and justifiable reasons, it was not permissible for the court to stop investigation by quashing an FIR. So these justifiable reasons have not been able to be shown, my lord, while bringing, my lord, this FIR. Now, my lord, kindly see paragraph 31, my lord. The power under section 482 CRPC might be exercised to prevent abuse of the process of law, but only when the allegations, even if true, would not constitute an offense and or were frivolous and vexatious on their face. So, my lord, the demurrer is that whatever allegation is there in the FIR is to be, my lord, considered to be true, my lord. If that is considered to be true, and thereafter, my lord, no offense is made out from the reading of that, my lord, lines which is there in the FIR, only then, my lord, the court will exercise the power. Where the accused seeks quashing of an FIR invoking inherent jurisdiction of the High Court, it is wholly impossible for the High Court to enter into the factual area to adjudge the correctness of the allegations in the complaint. Reference may be made to a decision of this court in so and so, so and so, so and so. Thereafter, my lord, which is given, my lord, how it has been decided. And in paragraph 37, my lord, in the next column, your lordships will find, in this case, it cannot be said there were no allegations which prima facie constitute ingredients of offences under section 420, 409 and 34 of the Indian Penal Code in complaint. There were clear allegations of fraud and cheating which prima facie constitute offences under section 420 of the Indian Penal Code. The correctness of the allegations can be adjudged only at the trial when evidence is adduced. At this stage, it is not for the High Court to enter into a factual arena and decide whether the allegations were correct or whether the same were a counterblast to any proceedings initiated by the respondents. Now, my lord, he says, because, my lord, these cases have been there, my lord, and, my lord, these cases, I knew it, And that is why I had filed the FIR, my lord. That is what he says. And that statement is squarely covered that even if it is that, my lord, the parameters under which this court will proceed has been laid down, my lord. Now, my lord, in Niharika, my lord, so far as Niharika goes,
Not necessary. Mr.
no, my lord, Niharika is there, my lord. Niharika in a later decision, my lord, Niharika has been referred, my lord. And what is the dicta of the Supreme Court here was, my lord, this is, my lord, 2022, volume 10 SCC, page 525. 22, 10 SCC, 525. Here, my lord, while dismissing the order of the High Court, my lord, it was held that the High Court lost sight of the directions contained in Niharika, my lord. And that is why that order passed by the High Court could not be considered, my lord. Ultimately, the FIR, my lord, was allowed to be continued, my lord.
Okay, okay.
My lord.
Yes, sir.
So, my lord,
Yes. Anything?
in paragraph 9, it appears from the impugned order passed by the High Court that the learned single judge has not properly appreciated and considered our earlier judgment and orders passed in Niharika. Even the learned single judge has not properly understood the ratio of the decision of this court in Niharika. It appears that the learned single judge seems to be of the opinion after giving reasons the High Court can grant an interim stay of further investigation in a case in a petition seeking quashing of the criminal complaint filed under Article 226 of the Constitution, read with Section 482 CRPC. The High Court has not properly appreciated the principles and the law laid down by this court in Niharika infrastructure. So, my lord, in the facts of this case, my lord, what transpires is not what is surrounding, my lord, and everything, my lord. What transpires for this court is to see, my lord, as to what is the contents of the FIR, and on the reading of the contents of the FIR, whether, my lord, any case is made out or not. And on these surrounding statements made, my lord, like a civil court, my lord, when, my lord, they will go in appeal, my lord, then the appellate court will see, because, my lord, as rightly, my lord, it has fell from your lordship's mouth, my lord, that this court is not sitting as a appellate court or a review court of review, my lord. So under this consideration, it is my respectful submission, my lord, that those conditions made out in Niharika has not been made, my lord. This is not an abuse of the process of law, and neither, my lord, these proceedings have been brought with any other intention in mind other than, my lord, for the sake of justice.
Okay,
This is my humble submission.
okay,
My lord, if I may submit.
okay.
My
I
lord,
will, no, wait. Let her, let her.
Your lordship, we now give on court number 7, your lordship. He has to continue the matter after break.
Pardon?
They are praying to, my lord, continue this matter after the break, my lord.
After the break.
Break, my lord.
Okay, yes, Mr. Singh then.
my lord. That is, my lord, what I understood by his submission is that he says, my lord, that is the first loan, he has given the NOC, but of the top-up loan, that was taken by committing fraud. So is this correct? Because,
Safi, don't ask
my
me.
lord, because this is what his submission was. So, my lord, if that is the case, because his submission will be then contradictory to the statements made by the informant in the FIR. Because it is clearly stated, my lord, that both these loans were taken by committing fraud. But now, whereas the council has submitted, my lord, that in the first loan he had given the NOC, that means he had the knowledge. Now, my lord, further.
The knowledge of what? Knowledge of the loan which was obtained from UCO Bank.
Yes, that is the first loan. That is the first loan, my lord.
The case relates to those top-up loans taken later on, my lord.
The second loan. Now, my lord, that is no the admission.
The questions are not to be twisted like this.
My lord, not see.
Because just because the
I may be
statements
allowed
are
to
made,
submit.
my lord, a bunch of documents are given here and there,
No,
my
no.
lord. And in the petition, my lord, where the powers under section 482 is being invoked. My lord, where is the question of, my lord, all
I
these
may be-
submissions, my lord?
My lord, if I may submit, my lord, now it is a prima facie, my lord, there is a contradiction as per the statements made by the council, because now he says that the second loan was taken. That is the top-up loan. In the first loan, if he had given the NOC, that means the consent was there. He had the knowledge, my lord. And but in the FIR, it has been stated, my lord, clearly stated at multiple times that both these loans were taken without his information, knowledge, or consent by forging his signature. This is a relevant point, my lord, because this proves that the that the bulk of the FIR is misleading. And now the question will again come up to only the second loan then. If in the first loan he has given the NOC, then it comes to the second loan. Now, my lord, the relevant submissions that I have made, prima facie case does not appear because, my lord, I have also given an relied on judgments on day one. I have submitted it, my lord. It is in the case record. Mahmood Ali and others versus State of UP and others, my lord. It is in the case record, my lord. At page 6, my lord, of the judgment, Mahmood Ali and others versus State of UP and others.
Yes.
Page 6, my lord. Page 6, paragraph number 11. The entire case put up by the first informant on the face of it appears to be concocted and fabricated. At this stage, we may refer to the parameters laid down by this honorable court for quashing of an FIR in the case of State of Haryana versus Bhajan Lal, so and so, and these parameters were laid down, my lord. And this first parameter, my lord, that where the allegation made in the first information report or the complainant, even if they are taken at the face value and accepted in their entirety, do not prima facie constitute an offense or make out a case against the accused. This first point, my lord, and point number 5.
This supports me.
My lord, point number 5, I'll explain that, my lord. Point number 5, where the allegations made in the FIR or complainant are so absurd and inherently improbable, on the basis of which no prudent person can ever reach a just conclusion that there is sufficient grounds for proceeding against the accused. Point 7 also, my lord, where the criminal proceedings is manifestly attended with malafide or where the proceeding is maliciously instituted with ulterior motive for wreaking vengeance on the accused and with the view to spite him due to private and personal grudge. This is also relevant, my lord. Now, the allegation in the FIR is, my lord, that the said loans were taken and then the intention of the accused person is to sell off the property. This has been argued by the learned counsel, my lord, that they want to sell off the property and not give the share to the informant. And it has been taken without.
I have not said that. I have not.
They wanted to sell off the mortgage property. This is what the submission was. Now, my lord, it is not prudent, my lord, because the petitioner, along with her late husband, invested their resources and time to accumulate wealth for the benefit of their descendants, my lord. Here, the descendant is also, informant is also one of the descendants. He's the son. Often at the expenses of their own desire, parents, at the expenses of their own desire, they accumulated wealth to construct the said property, where not a single brick has been, my lord, put by the informant. As time passed, children matured and it appears so did the avarice. Regrettably, the applicant who has filed the IA, my lord, has lodged a legal complaint against the mother, accusing her of criminal offences, thereby disregarding the numerous sacrifices his parents has made for his upbringing. Additionally, he fails to acknowledge that the assets in contention are in fact the result of his parents' own hard-earned efforts, my lord.
My lord,
Now I may be allowed to complete.
My lord, virtuous lectures, my lord.
No, my lord, it is not virtuous lectures.
So these virtuous lectures, my lord, perhaps this is not the proper forum.
Please,
Court, my lord.
So, my lord. So now he says, my lord, the mother who has made numerous sacrifices through her life has destroyed her own property, and now because my lord, she has no other home. Where will she go if this property is auctioned off? She is the one who is trying to save the property. She has no other home. The informant, he is a government servant, my lord. He'll adjust somewhere. Because the mother has said, because I'll give the ground floor to somebody else. He's prejudiced by that. And because of that, my lord, now he is saying that now he wants to wiggle out from the responsibility that he has taken upon his shoulder by entering into this agreement. He is of the opinion now, because, my lord, that is, if I pay the EMIs now, I will still not get the ground floor. Now he wants to wiggle out from the responsibility. He has manufactured this false FIR before trying other things, manufacturing false will. That did not help him. He then filed the FIR so that he can wiggle out from paying the EMIs. This is the case, my lord. So this, my lord, prima facie, it appears to my understanding that, my lord, it is a false, frivolous FIR filed with ulterior motive to wreak vengeance upon the mother, so that she can be compelled to withdraw her DV case.
okay, we'll continue after. So Madam, your works, Mr. Nagpur remain present at 3 o'clock.
গাঁৱতো মানে থাকি গ'ল নাই গাঁৱতেও থাকি গ'ল এইকাৰণে
Mr. Khatamir, please.
Item 8. Sorry, item 9. Item 9.
Lordship, the case diary I have already placed.
Yes,
It,
yes.
it reveals, Lord,
Yes.
that some FSL report has come and the investigation is at the stage of awaiting the other FSL reports. Because the FSL reports which are available on record, it suggests that the loan application form and the specimen signature given by the complainant are different.
Hmm.
So as regard the scope of 482, Lordship, the Lordship has heard the matter, Lord. My respectful submission would be, Lord, since the case is under investigation and the FSL reports, those are awaited. At this stage, Lord, the proceeding, the honorable court may not take a decision whether this proceeding is on the merit of the case, Lord. But I'll just place a decision of the honorable apex court here. There, the honorable court has, in fact, court has said that when the matter is under investigation and the FSL reports and all are awaited, then in that case, the High Court has interfered. Honorable apex court has said that court should not have interfered. Honorable Supreme Court has set aside that order. But that decision I'll place, Lord, 2018 5 SCC 678.
2018.
5 SCC 678.
678.
678.
Okay.
It's a small judgment. Malad, I'll read that particular paragraph, the concluding paragraph, Malad. In the if necessary, Malad, I'll take your lordship to the facts also. Malad, in the light of the fact that the inquiry is pending and there are aspects which may require investigation, we are of the considered opinion that the High Court erred in quashing the FIR at the threshold itself without allowing the investigation to proceed. We cannot agree with the reasons provided under the impugned judgment concerning certain factual assertion made by the respondents as to the condition of the deceased and the reasons for committing suicide, because acceptance of the same would not be in consonance with the settled jurisprudence under section 482 of CRPC as laid down by various judgments of this court. So like there, the husband has committed suicide and suicide notes are there. Ultimately, on the factual assertions were accepted by the High Court and the FIR was passed. Well, my respectful submission in this case also, so the petitioner has, by referring to various documents, in fact, I don't know whether these have been during investigation, this has been placed before the investigating authority or not. So these are matter of investigation. If the informant has admitted at some place, or he has himself has stated that he is a part of that in the transaction when the loan was taken, or those matters can be definitely placed before the investigating authority, and the investigating authority can probably take care of everything. So the documents which are available here, ultimately during the course of investigation, that has to be placed before the IO, before the investigation. Those are part of the investigation, and on the basis of those factual assertions, my respectful submission would be that at this stage, since Lordship will see whether their investigation to unearth the allegation is may be correct, may not be correct, but whether to unearth the allegations, the investigation by an IO is required or not. The principles, I'll not take your lordship to the principles which are already well settled in the case of Bhajan Lal, that if those are there, then court will interfere, otherwise not. Here, lot of factual disputes are there. Lordship has seen some many documents are in fact annexed in the petition itself.
No, while dealing with a petition under section 482, the court cannot embark into the disputed question of law.
That is the
Mm.
crux of the matter. That is the crux of the matter. When the investigation is required in a case to unearth the truth, the lordship may not enter into the merit of the factual things.
No, my question is whether after perusal of the FIR, a prima facie case is made out or not.
It is there.
It is there.
It is there.
It is there. And
Now, the petitioner has submitted before the lordship by referring to various documents that the contention made in the FIR that he has come to know about this loan taken by them at a later stage in the month of December. It is not true. That they want to show. My respectful submission is that those documents has to be placed before the investigating authority, IO. Ultimately, it's a matter of investigation. If these documents are there, the apprehension of the petitioner hearing that she is a 75 years old lady,
yes,
that can be taken care of by the honorable court. During investigation also, if her custodial detention may not be required in all cases, these are papers are there, that protection, if the sole intention of the petitioner is that not to have any harassment to the petitioner, that aspect can be taken care of. There are ways and means. But the investigation may not be closed at this only for that. See, the 75 years old lady, that's true. But lordship is, these things are ultimately the investigation will reveal what is the truth. Maybe the respondent, private respondent, he may be at fault. After investigation can only it will reveal. Without going into the merit of all this, my ethical submission is that at least at this stage, entering into the factual disputes, lordship may not interfere with the affair.
but Mr. Nath, so by order dated 6/11/2023, we have state further investigation. This now how can you take carried out investigation?
But those are
Can take
those are 23, October 23.
October 23, not
23.
thereafter.
No, not after that. But the last page date is not available, but just the second last page, lordship will see. It is I think it is October or something in 2023.
Okay,
Not after that.
okay. Okay, okay then. Okay. Yes, anything,
yes,
Mr.
my lord.
Sodori?
My lord, lordship may peruse one more judgment, my lord. That is 2019, volume 14 SCC, page 350. At paragraph 9, my lord,
2019.
19,
Yes,
14 SCC
yes.
350. Paragraph 9, my lord.
Okay.
Here, my lord, lordships have held, having heard the learned senior counsel and examining the materials on record, we are of the considered view that the High Court ought not to have set aside the order passed by the trial court issuing summons to the respondents. A perusal of the complaint discloses prima facie offences that are alleged against the respondents. The correctness or otherwise of the said allegations has to be decided only in the trial. At the initial stage of issuance of process, it is not open to the courts to stifle the proceedings by entering into the merits of the contentions made on behalf of the accused. So, my lord, even any merit, if any contention is made as regards the merit, my lord, on behalf of the accused, that is not to be seen by this court. That is my humble submission.
Okay. Yes, Mr.
Hello.
Singh.
My lord, their entire argument, of course, is based on the FSL report, which suggests that the signature are forged, my lord. But then on the other hand, I am giving a conclusive proof. And if my submission and the submission of the informant that he has made before the trial court are considered, the ingredients are not present, my lord. That I may be allowed to submit, my lord, It's only 4-page submission, my lord. After that, I'll rest my case, my lord. That is in the IA. I have mentioned it at page 20. That may be, I may be allowed to read that, my lord. Page 20 of my affidavit in opposition in the IA. Page 20.
Yes.
My lord, that the offense of forgery under section 461 IPC postulates that whoever commits forgery intending that the document or electronic document forged shall be used for the purpose of cheating shall be punished with imprisonment without description or for a term which may extend to 7 years and also shall be liable to fine. Whereas the section 71 IPC states that whoever fraudulently or dishonestly uses a genuine any document which he knows or has reasons to believe it to be a forged document shall be punished in the same manner as if he has forged such document. Now, my lord, there are two primary components that needs to be fulfilled in order to establish the offense of forgery, namely that the accused has fabricated an instrument. It was done with the intention that the forged document would be used for the purpose of cheating. Simply put, the offense of forgery requires the preparation of false document with the dishonest intention of causing damage or injury. Now, my lord, the offense of forgery and cheating intersect and converge. That means, my lord, if forgery is not proved, neither will be the cheating. That is the subsequent effect of forgery. My lord, then thereafter, my lord, now to address the first element in forgery, that is the preparation of false document, the determination of whether the accused persons conspire to prepare a false document by forging applicant's informant's signature cannot be solely replied on FSL report, as there can be numerous reasons for signature mismatch. Now, my lord, the learned counsel for the state had submitted that the informant himself has submitted his signatures. My lord, his intention now is to wiggle out from the responsibility. He himself can deliberately put his signatures wrong so that the FSL report can be in his favor. He can do that, my lord, because his intention now is to wiggle out from the responsibility from paying the EMIs. Further, my lord, however, the humble old OP wants to draw the attention of the Honorable Court to the voluntary act of the informant applicant to take over the said loan amount mentioned in the impute MFIR dated 2/12/2022 by executing a notarized agreement dated 17/3/2020, which eliminates the primary ingredient of dishonest intention itself, my lord. Now, when dishonest intention itself is when he himself has taken over the loan, that dishonest intention itself goes away, my lord. Therefore, my lord, the offense of forgery has no legs to stand on. This is my submission, my lord. When forgery is not relevant, neither will be the cheating. Neither cheating will be relevant, my lord. Further, my lord, now if I come to the section 420 that she has been charged with, the section 420 of IPC provides that whoever cheats and thereby dishonestly induces the person deceived to deliver any property to any person or to make, alter, or to destroy the whole or any part of valuable security or anything which is signed or sealed or which is capable of being converted into a valuable security shall be liable to be punished for a term which may extend to 7 years and shall also be liable to fine. Further, my lord, section 415 of IPC distinctly defines the term cheating. The provision elucidates that the act marked by fraudulent or dishonest intention will be categorized as cheating if it is intended to induce the person so deceived to deliver any property to any person or to consent that any person shall retain any property causing damage or harm to that person. Thus, it is paramount that in order to attract the provisions of section 420 IPC, the prosecution has to not only prove that the accused person has cheated somebody, but also that by doing so, he has dishonestly induced the person who is cheated to deliver property. There are thus 3 components in the offense. That is deception of a person, fraudulently or dishonestly inducing that person to deliver a property to any person, mens rea or dishonest intention of the accused at the time of making the inducement. There is no gainsay that for the offense of cheating, fraudulent or dishonest intention must exist from the inception when the promise or representation was made. Further, my lord, the Honorable Apex Court in Catena of Judgments has held that every deceitful act is not unlawful, just as not every unlawful act is deceitful. Some acts may be termed both as unlawful as well as deceitful. and such a loan will fall within the purview of Section 420 of IPC. It must also be understood that the statement of facts, it is deemed deceitful when it is a false and is knowingly or recklessly made with the intent that it shall be acted upon by the other person, resulting in damage or loss. Cheating, therefore, generally involves a preceding deceitful act that dishonestly induces a person to deliver any property or any part of valuable security, prompting the induced person to undertake the said act, which they would not have done otherwise but for the inducement. The term property, my lord, then further has been employed in Section 420 of IPC as well as defined connotation every species of valuable right or interest that is subject to the ownership and has an exchangeable value is ordinarily understood as property. It also describes one's exclusive right to possess, use, and dispose a thing. The IPC itself defines the term movable property, that is at my lord Section 22 of the IPC, as intended to include corporeal property of every description. Corporeal in the sense, my lord, that is tangible in nature, except land and things attached to the earth or permanently fastened to anything which is attached to the earth. Whereas immovable property is generally understood to mean land's benefit arising out of land and things attached to the permanent fastened to the earth. That is respectfully submitted after fully addressing the contours of the offense of cheating. The humble OP number 1 prays for this honorable court's attention towards the facts of the instant case, as to appreciate whether the allegation made by the applicant informant are sufficient to prima facie establish that the accused person have deceived the applicant informant, or applicant informant was induced with dishonest intention, or such inducement was for delivery of any property or valuable security. As a result of such an act, informant and applicant has suffered some damage or injury. Now, my lord, each of these ingredients are necessary to analyze to ascertain whether the informant applicant has made allegations in his complaint to substantiate points 1 to 4 above. The crux of the applicant's informant's allegation is that the accused person purportedly forged his signature on the bank papers submitted to obtain 2 loan amount mentioned in the impute FIR dated so and so. In the peculiar facts and circumstances of the case, the writ petitioner has been accused to have the notion of family mutual family trust, my lord, which is out of maternal bond, that is between mother and a son, and unauthorizedly projected informant's consent in obtaining the loan from the bank. My lord, this is the important part, my lord. It, however, remains a question as how to such an act allegation can be labeled as deceitful, where the informant applicant has himself been paying the EMI since 2020. Because, my lord, that cannot be called cheating because he himself, it cannot be called deceitful because he had the knowledge since 2020. He has been paying the EMI since 2020. And further, voluntarily executed a notarized agreement with the accused number 3 to take over the said loan amount and paying the remaining EMIs. The applicant informant has further written emails to the bank official that also have annexed, my lord, as my document to the bank. He has written emails to the bank official intimidating them about his takeover of the loan mentioned in the impugned FIR dated so and so. The motivation prompting either of the accused person to procure a loan for the construction of the 2nd floor of the shared RCC building were not rooted in deceit. Furthermore, the grant of loan to the accused number 3 did not confer any benefit upon the opposite number 1, my lord. This loan actually went to the bank account of accused number 3. He is the second son of the writ petitioner, my lord. The petitioner did not get any benefit of when the loan application was applied. She did not get any benefit. She was only a co-applicant. The entire loan amount was transferred into the bank accounts of accused number 3. Nor did it result in any loss or damage upon the applicant informant, as the applicant voluntarily took over the said loan amount from accused number 3 and took the respective share of the accused number 3 in the shared property, my lord. Now, their argument is, my lord, that is he was paying the EMI to save the property. That is not justified, my lord, because he could have paid the EMIs by not executing that notarized agreement. He could have still paid the EMIs by compelling his own brother to relinquish the rights in the property. This was not necessary.
I may be
Okay.
allowed to do that.
Okay.
My lord, because their submission is he was paying the EMIs to save the property, but he entering into an agreement with the accused number 3, whereby he tells the accused number 3, I will pay the EMIs only in one condition: if you relinquish your rights in the property. That was not necessary for him to do it if his intention was only to save the property, my lord. So, my lord, the necessary ingredients after taking into the account of his submissions before the trial court, the necessary ingredients that are there, my lord. Be it in forgery, that is the primarily allegation. If forgery is not proved, my lord, then cheating will also not have a foot to stand on. My lord, the initially responsibility to pay these EMIs was taken by the by the accused number 3, but when he lost his job during COVID-19 pandemic, the applicant informant took this opportunity to grab the entire property. Now, my lord, taking into account of all these relevant submission that he has made before the trial court, I believe, may not, again, with my limited understanding in the field, that I believe that none of the ingredients are present in the case to initiate further investigation, which my lord, will be abused in the process of law. And my prayer is, my lord, that it may be quashed altogether. And further, my lord, the conduct exhibited by the informant against his own mother can also be, my lord, it should also be relied on, because that itself, my lord, filing of frivolous FIR itself amounts to cruelty also.
Heard Mr. Ising, learned counsel for the petitioner, Mr. G. Chaudhary, learned counsel for the respondent number, you will put the respondent number 2.
My lord.
Mr. D. K. Nuts, learned senior government advocate for the respondent number 1. Argument concluded, order reserved.
My lord.
Madam, we will retain the CD till order is passed.